Hello and welcome to this webinar on board portals and voting, presented by Corporate Secretary along with our partner and sponsor for this event, Diligent Board Member Services. And of course, Diligent Board Books is the world's most widely used board portal. We're live tweeting this event at hashtag CSM webinar. Do add your comments there. That's hashtag CSM webinar for Corporate Secretary Magazine webinar. I'm Neil Stewart. I'm Editorial and Research Director at CrossBorder, the publisher of Corporate Secretary, and I'm your moderator today. As we go along, we do welcome questions from the audience. Just type them into the question box on your webinar screen. So, the topic, voting on board portals. Now, if you've dialed up this webinar, you already know that board portals have introduced a ton of efficiency into board books and meeting procedures, and all that process has multiplied and accelerated since iPads and other tablets have come along. At public and private companies as well as nonprofits, boards are using portals for convenience, for security, savings, and labor, time, and cost. Now, a key goal of board portals, really is the goal of good governance, is better decision-making, faster decision-making, which makes it perplexing that voting, which is one of the features of board portals, is not being used very much. So that's really what we're setting out to examine today. General counsels and corporate secretaries have access to new ways to process time-sensitive board approvals, unanimous written consents between board meetings, for example. So this webinar will examine how to conduct a legally valid vote with your board portal, as well as other uses for the polling function. Now, to aid us in this, we have invited an expert in Delaware corporation law to join us. He's John Mark Zaberkowitz, director of the law firm Richards, Layton & Finger. John Mark handles M&A, governance, corporate finance matters involving Delaware corporations. He's even been involved in drafting amendments to Delaware law, and he's a frequent speaker on the topic. He's published numerous articles in the area as well. Along with John Mark, we have Jeffrey Powell, Executive Vice President of Sales for North America at Diligent Board Member Services. Now, Jeff is responsible for the development and execution of client acquisition strategies throughout the Americas. Now, just before we hear from Jeff and John Mark, let's take a quick temperature check of the live webinar audience. We're going to do our own voting here, a vote about votes, if you will. Please participate on your computer by clicking on one of the multiple choice answers. So let's take a look at the first polling question. Does your board currently use a board portal? So if we could just have the audience vote, we'll find out where we are with our participants. And as you can see, I'm going to close the voting there, and over 90% of our audience is already using a board portal. Now, the next question, question number 2, is out of those who use a board portal, do you use it for voting and or polling in any way? Okay, so again, please vote. This is for everybody who is using a board portal. Do you use it for voting and or polling? Again, I'll end the voting there, and nearly 75% are not yet using it for polling. Now, interestingly, in the society poll, the Society of Corporate Secretaries and Governance Professionals poll that was conducted this summer, it was a fairly small sample, but of that group, 29% said they were using voting functions on their board portal, so just under what we were seeing just under amongst our audience, so about 27% compared to the Society's 29%, so pretty consistent. Now, back in the spring in one of our first webinars with Diligent, we got a good question from one of our listeners, and that is we do use a board portal to distribute all those meeting materials and reference materials, and it's great. It has changed the game, but my question is about what is around the corner, the next big thing. So perhaps voting could be it. Let's get some context now from Jeffrey Powell from Diligent about some of the history of the adoption of board portals, but moreover, the use of the feature of voting. Jeff, set the scene for us, please.
Okay, thanks, Neil. I appreciate the introduction, and it's, of course, very nice to be here at this webinar with you and John Mark. Diligent has a long-standing relationship with Corporate Secretary, and we're very happy to be here doing another webinar. Now, of course, since most of you responded that you are currently using board portals, I will spare going into much detail about them, but for those of you who may not be using them, and also to set the stage a little bit, Diligent really pioneered the use of electronic board portals in 2001 as a way of replacing the traditional paper-based method of distributing materials to boards of directors. Now, of course, at first, I mean, this was a big change in the industry. It was a big change in the way organizations communicated with their board. So for many years, that's really just what the focus was on, was going merely from paper books to electronic books. And over time, of course, the board portals became accepted as a form of corporate governance and adopted by a wider and wider segment of both public and private organizations. But as opposed to really being focused on the features of the portal, over the years it really has just been focused on the main dynamics of what you might call the bread and butter of the system, which is distributing board books to board members, executives, staff members who might need to access the materials. Now, whereas the main purpose of the system is, of course, to distribute those board books, to let users have real-time access to them, to make it much easier to compile and distribute these materials, it also does give the end users, the board members, the ability to annotate the pages, that is, making their own sets of notes on them, and increasingly use them on a varying degree of devices. Whereas, of course, the board portals first came out before tablets were even in existence. In recent years, the iPad in particular is, the device of choice, the most popular choice for board members accessing board portals. But now that, the technology has been around for a while, that, board members, whether or not they're using a board portal, probably know what it is. It's more of an accepted technology. There has started to be more of an emphasis on features. And this takes the form of distributing materials to a wider array of users at a company, that is not just boards, but committees or other user groups, and also giving those users a greater flexibility in not just how they view the materials, but how they can respond to the materials. And Neil, as you're talking about, perhaps that next big thing is voting. And when we're talking about voting, we're talking about a couple of things. Mostly I think what John Mark is going to talk about is unanimous consent, but there are some other uses on the voting that we'll come back to later on in the webinar. But for us, it is kind of surprising that at this point in time, only about a fourth or perhaps 30% of board portal users are using voting, because for us at Diligent, it's long been a part of the system, where an end user, a board member, could be reviewing materials and could have the ability to vote on it and attach their electronic signature to it. So I think that's the context of what we're talking about today, Neil.
Thanks, Jeff. So board books have been around since 2001. Voting has long existed on board portals, more recently on iPads. But really, board portals are being used as a way of assembling and distributing board books, and not necessarily for the additional features like voting. So this is what we really want to focus on today on the webinar. Let's ask another quick polling question before we hear from John Mark and to get into further detail. So question number 3 for our audience. Now, this is actually for that 27% of our audience who do already use board portal voting. So we're winnowing down the sample here. But we want to know how you use it. So is it A, to collect signatures between meetings, for example, for unanimous written consents? Is it B, during meetings? Or is it C, both between meetings and during meetings? So let's find out what our audience is saying. This is for the 27% of our audience that have indicated they do use voting via board portals. And as you say, Jeff, we're going to go into more detail about using voting during meetings. Just briefly, tell us a little bit about the sort of convenience or transparency. If we were in a board meeting, perhaps some people participating by telephone, most people in the room, and we wanted to do a poll via the board portal, what does it look like, and how is it maybe better than hearing a voice vote?
Well, there are, of course, options on how a particular client may customize their voting pages to look like. But essentially, in the most common use right now, what we're talking about is a board meeting where you've got a variety of users sitting around with their iPads. And using Diligent board books, it enables you, if everybody is online, it enables them to be attaching their signatures, that is, voting on something, say voting to approve something, and their signatures will pop up in real time. So, for example, if you and I were in a board meeting and I were to vote on something in the affirmative and attach my signature, on your page that you're looking at, you would see my signature pop up. So it's another of these real-time features where not only can users have an ease of access for voting on something and attaching their signature, but it's happening in real time that can be transparent to the other people participating in the vote.
Okay, so it's quicker and it is more transparent. It's easy to see how many votes you've collected and who has voted. So we'll close the voting there on our little poll. And as we can see, really the vast majority of people who are using voting on this call are using it between calls for collect signatures, for example, for unanimous written consents. Very few are using it during meetings at this point, and a small handful of people using it for both. Okay, well, let's hear now from John Mark Zaberkowitz from Richards Layton. Now, we know that among diligent clients that have, are using the board portal but are not yet using the voting function, the questions they have are typically legal in nature. What you can and cannot use e-signatures for, the necessary audit trails, any bylaw changes they may need, and these are all good questions for our expert lawyer to answer. So, John Mark, give us your view as an expert in Delaware corporation law, in particular how you see the benefits of using a board portal in place of, for example, written consent by email.
Got it. Thank you, Neil. This is John Mark. I'm a director at Richards Layton Finger in Wilmington, Delaware, and I'm going to be addressing this topic from the standpoint of a Delaware corporation. Clearly, whether actions can be taken effectively, in other jurisdictions is a function of the law of that other jurisdiction. I'm going to focus primarily on the Delaware General Corporation Law, which I'll refer to as the DGCL. And in that context, board portals, as you've heard, can be incredibly useful tools in providing notices to directors, furnishing materials to directors, soliciting approval by unanimous action in lieu of a meeting. Start off with notice. With respect to notices, the DGCL, doesn't really squarely address the manner in which or the time by which notice must be furnished to directors. Those items are typically addressed in the corporation's bylaws. The manner in which notice is provided and the time by which it's provided may be also subject to fiduciary considerations. How long do directors have, to receive the notice and the materials that are included? That type of thing may be a function of, both the bylaws. You'll have provisions on how long you have to give them depending on how it's furnished, 24 hours, 48 hours, 3 days, as the case may be, depending on the type of notice that's provided. Those things are always addressed in the bylaws. When you're talking about notice through a board portal, notice of a board meeting through a board portal, one thing that is important to make sure is that the bylaws actually allow for notice through electronic means. Some bylaws of older vintage still require that notices be mailed in paper, things along those lines. It's important to kind of refresh the bylaws to provide for notices by electronic transmission. Also, in the case that notices are being provided through a board portal, it may be important to also ensure that notice is provided through some other means, like an email alert or through some other customary means of notice. Certainly, materials is probably one of the furnishing materials and circulating materials to directors. Probably one of the biggest advantage of the board portal over, other means that are currently used. Perhaps one of the most common means now used is email. And email has been great in terms of providing, information and a lot of information and books to directors. But it really is not as convenient to directors, nor is it necessarily as secure as furnishing those meetings through the board portal. With a board portal, the directors have all of the materials that are necessary for a meeting, and other materials and organizational documents regarding the company in one place, and that place is safe and secure. Now, one thing I do want to touch on, though, in terms of materials that are being furnished to directors and the ability of directors to annotate those materials. As with, and this is applicable, not just with board portals, but I do want to mention it in this context anyway. As with all materials provided to directors. Directors should, take notes if it is their practice to do so. However, whenever directors take notes, whether it's annotations on electronic documents stored in a board portal or notes that they take in paper form, they should be absolutely certain that their notes are not capable of being misunderstood. The notes have to be absolutely clear if it is their practice to take them, because as with all communications, there is always a possibility that anything that's written down could someday be produced in litigation. So that's kind of a brief, discussion of kind of materials and notice. I want to focus now on the main topic, and that's board action through a portal. And this is where I think board portals can be, probably the most powerful and groundbreaking tool in a while. And that is that board portals really can facilitate action by written consent, unanimous action of the board outside the context of a meeting. And Section 141F of the DGCL provides, unless otherwise restricted by the Certificate of Incorporation or bylaws, any action that's required or permitted to be taken at a meeting of the board or any committee of the board may be taken without a meeting if all members of the board or the committee consent in writing or by electronic transmission. And that writing or the electronic transmissions are then filed with the minutes of the proceedings of the board or the committee. The statute goes on to say that the filing shall be in paper form if the minutes are maintained in paper form, and shall be in electronic form if the minutes are maintained in electronic form. So Section 141F clearly permits unanimous action by electronic transmission. And the statute then defines in a separate section, it's Section 232C, defines what constitutes electronic transmission. And that's any form of communication not directly involving the physical transmission of paper that creates a record that may be retained, retrieved, and reviewed by a recipient thereof, and that may be directly reproduced in paper form by such a recipient through an automated process. So in the case of board portals, the typical board portal is structured such that when resolutions are submitted by approval or submitted for approval by the board or the committee, each director would receive a copy of the resolutions proposed to be adopted by unanimous action by the board or committee. And the board portal would include the underlying materials referenced in the resolutions, and directors would then use the board portal to provide that consent by electronic transmission. All of that would satisfy the requirements of the DGCL. So a couple of things to keep in mind, though, is that unanimous action outside the context of the meeting means just that. It has to be unanimous. And so when you're thinking about action that is being taken outside of the meeting, one thing that often comes up is, what do you do about directors who, say have a conflict of interest, or they believe they may have a conflict of interest? Do they have to participate? The answer is yes, absolutely. Whenever you're acting, outside the context of a board meeting, each director, unanimous means unanimous, and each director must execute the consent. And if that is not the case, if it's not advisable for a specific reason, then the action should be considered at a meeting, and that director or those directors who believe they have a disabling conflict should abstain or recuse themselves from the vote, and then the remaining directors, assuming they constitute a quorum, can consider the matter, or the full board should create a committee to consider the matter outside the earshot of those directors who have a disabling conflict. And that is applicable regardless of whether the action is being taken in the traditional form of folks signing pieces of paper to evidence their consent to the action, or the board portal. But it's just an important thing to remember that that is the case with actions outside the context of a meeting. So a couple of things to keep in mind in the context of using board portals for action by unanimous consent of directors. The corporation should ensure that, as with email, there are procedures in place to ensure that only directors and not other persons have access to the board portal. Each director should be required to log in with a unique password, and corporations should implement, safeguards to, support the presumption that the consent that's actually delivered through the board portal by the director is in fact delivered by the director, him or herself, and not by some other person. It's very important for purposes of Delaware law that consents, whether they're given, in paper form or through electronic transmission, in fact be given by the director and only the director or directors. Another thing to keep in mind for corporate secretaries is that when consents are delivered electronically, the corporate secretaries have to follow, the appropriate procedures for filing the consents with the minutes of the proceedings of the board or the committee. As I previously noted, Section 141F, which allows action by written consent or action through electronic transmission, that section provides that the filing shall be in paper form if the minutes are maintained in paper form, and shall be in electronic form if the minutes are maintained in electronic form. So where the minutes are maintained in paper form, as is the case with many corporations, still have minutes in paper form. If that is the case, then the consent that is received through electronic transmission actually needs to be printed out and placed with the minutes of the proceedings that are maintained in the binder or binders. If they're maintained in electronic form, they should be maintained in electronic form, stored, but they have to be stored in a manner in which they can be reproduced into paper form at some point through an automated process. Section 224 of the GCL deals with, electronic records, provides that, records maintained by the corporation in the regular course of its business may be kept on or by means of or in the form of information, any information storage device or method, provided that the records can be converted into clearly legible paper form within a reasonable time. Section 224 also provides that the corporation would be required to convert any records maintained in electronic form into paper form upon a request by any person to inspect the records, and that would be in the case of say, a 220 action by a stockholder to seek books and records. So those are some of the major issues that come up, in the context of, providing notice, furnishing materials, acting by unanimous action of the board or any committee outside the context of a meeting. One of the things that we've been kind of talking about at the outset of this, and that we've been raising, is the notion of using board portals for voting during meetings. Now, obviously, voting during a meeting is a very different thing from acting by unanimous written consent under Section 141F. Voting at a meeting is, assuming a quorum is present, you need a majority of a quorum, typically, unless the bylaws or charter require a greater number, but typically it's a majority of the quorum to approve the action. Often, in the course of a meeting, a resolution will be submitted to the board. The chairman will move the resolution. One of the other directors will second it, and then there will be a voice vote. And the secretary will record, whoever's acting as secretary of the meeting will record the vote of the directors. And that is a fairly customary practice. That recordation of the vote is then reflected in the minutes, and the minutes serve as evidence of the action that was taken at the meeting. To the extent that votes are taken through the board portal during the context, during the course of a meeting, it is pretty important from my standpoint for folks to ensure that, that is voting at a meeting, and it is not, clearly not, and there's a clear delineation that it's not an action by written consent, nor is it intended to be an action by written consent, but rather it is just a recordation of the vote. The other thing to be mindful of in this context is that if you are taking a vote through a board portal at a meeting, it is important to ensure that there's some record in the minutes that everyone is either on the board portal and has voted through the board portal, or if there are some folks who are not voting through the board portal, that somehow gets reflected in the record, because what I would not want to see is, a discrepancy between the vote as reflected in the minutes. Say, for example, that everyone pipes up and approves a matter, and the secretary records it as unanimously carried, but say only 3 of the 7 directors in fact approved the matter through the board portal. You'd want to make sure that there's some record that kind of clarifies any discrepancy that could arise. So those are my only kind of two things to point out on voting during board meetings or committee meetings, and these apply, as I mentioned, with consents. They apply to both boards and to committees. But those are a couple of things that I think people should really be mindful of.
Great, John Mark. Thank you. That's a fantastic kind of lawyer's perspective on this, and to the rules and laws around, especially unanimous written consents. And it's clear. I mean, boards need to act quickly, and corporate secretaries and general counsel need to get their consents quickly. Say a board has to approve stock option grants before a company's stock price changes. You got to get it done fast. And with using a portal as opposed to say email, you're able to very quickly gather the votes and see a tally. And there's no confusion, right, around like what's attached to an email. Is it the right draft? What are they consenting to? But with a portal, it's faster, more efficient. Now, let's quickly, we've got some questions coming in from the audience, and let's sort of tackle a few of these as we go along and also hear from Jeff. But the first one we got was, is this state by state in terms of being able to vote electronically? And John Mark, you prefaced your remarks by pointing out you're talking about Delaware corporation law, and that's what you can address. It seems to me that the Delaware rules that allow portal voting are the same ones that allowed for email voting. So it's fair to assume, I would think, that if a state allows email voting, it allows portal voting. And most states allow email voting, right?
I would expect. Obviously I can only speak to Delaware, but I would expect that most states that allow email voting, I would imagine that their statutes are broad enough to encompass portal voting. I would be surprised. I don't know firsthand, but I would be surprised to see a statute worded so narrowly that it would only pick up, email as opposed to broader means of electronic transmission as the general corporation law provides. And so it is, though, it is important. It is a state-by-state analysis. It's also, as I mentioned earlier, it's also important to make sure that the organizational documents allow for it. I will tell you my experience. I have not yet come across a set of organizational documents that would prohibit it. But it's also even further than that. It's an entity-by-entity analysis. Even in Delaware, limited liability companies are subject to slightly different rules unless otherwise provided in their agreement. Unanimous action in writing is not required in the way it is with a corporation, but a majority of the managers can act outside the context of a meeting in writing. So it's an entity-by-entity analysis, state-by-state analysis, and also, important to look at the organizational documents. Okay, good. Now, Jeff, John Mark mentioned some of the safeguards that a corporation had to have in order to ensure, that the identity of directors voting, for example. The security of a board portal, when it comes to voting, is there any doubt around that, or is that ironclad?
It is ironclad. Of course, we're talking about how it applies to voting, but any time a user is accessing the portal, they're being required to log in with their unique security credentials. There are a variety of safeguards in place, but at a minimum, it's a username and a potentially complex password that is known only to that individual. So when a user logs into the system, not only is it absolutely secure, but also as it relates to voting, the system has the ability to also authenticate that signature or that vote with a date and time stamp. And also not just from a security standpoint, but from a regulatory standpoint, whereas, of course, the vote is being cast electronically, the company does have the ability to print out those votes as well, talking about those hard copy requirements that John Mark mentioned also.
Good. Okay. And, Jeff, I don't know if you can give us an answer on this question that we got from an audience. It looks to be an audience member in the UK asking about international board portal voting law. So obviously, Diligent has customers around the world. Do you know anything about the laws in other countries?
I really don't. I think that there may be even greater limits on the type of voting that it can be, or if it is just unanimous consent. But it's not actually something I'm particularly knowledgeable on.
Okay. And we have a couple of questions about, what can or what you should be using consents for. One of the questions we got here, maybe John Mark, you could field this. Are groups, are companies, I assume, or organizations using portals to approve board and or committee minutes? So when approving minutes, is that something you can use consents for?
Yeah, I mean, absolutely. That is one of the things that you could use a consent for, and certainly something that you could use the board portal for. And in fact, in many cases, that's a good use of the board portal. It's a very good use of the board portal. It's one of those things where if the minutes, are just customary minutes of an ordinary meeting, certainly using the board portal, after the meeting to circulate the minutes. Solicit the director's consent through the form of the minutes. That is a very good use of the board portal. The only time really I would say that might not be, a good use, and where maybe you would want to bring those minutes up at a meeting is if you know that there's some dispute among the board members about what the minutes, should say about what happened at the meeting. That's one of the few places where might not be a good use. But in that case, of course, you're not going to get unanimous action anyway.
Right.
But in the ordinary course, yes, it's a good use of the portal.
Okay. Thank you, John Mark. Now, two related questions here. This is for you, Jeff. The first question is how to coordinate with Diligent when setting up portal voting. So it's a good question. Like if you want to do a vote or you want to gather consents, quickly, what is the procedure and what type of coordination does it take with Diligent? And related to that, one of our audience members was asking about the mechanics of setting up the digital electronic signatures, the director signatures in the portal. Jeff, could you field those?
Sure, absolutely. And so the way that this typically happens is part of the implementation process where a client is working with their account management team at Diligent. And so it's something that someone could look forward to if they became a client, or if you are currently a client of Diligent and are looking to explore adding voting, you would coordinate with your account management team. Now, this is a process on our part of working with the people on the client side. Who are the users who are going to be involved in the voting? We have to physically collect and verify their signatures from them, digitize them, put them into the portal, make them available to be attached only by that individual user. It's not a complex process, but it does require not only the security requirements, but our account management team working with the appropriate people on the client side to turn on voting for them, teach them how to use it, and of course to train the end users how to attach their votes as well.
Good. Okay. Thank you. John Mark, a question for you, and that is from a Delaware law standpoint anyway, do nonprofits or private companies need to be aware of any different legal requirements?
No, the same rules that apply to public companies, organized as Delaware corporations, are equally applicable to private Delaware corporations, non-stock, non-profit Delaware corporations. All applies equally across the board.
Okay, and then we have one final question, which is kind of a broader question. This is a good one for you, John Mark, and it's about what is eligible for consents, for unanimous consents. The questioner here is asking how you reconcile the need for discussion, deliberation with the use of consents. Is it by limiting the subject matter of written consent? So what is appropriate for unanimous consents? Could you sum that up quickly for us, John Mark?
Sure. Certainly by statute, any action that is permitted or required to be taken by the board may be taken by unanimous action, by written consent or electronic transmission. That said, it's permitted under the statute to take anything, but the board may consider limiting its use to unanimous written consent to very automatic type matters, things that don't require a great deal of discussion or deliberation, routine, stock option grants by a compensation committee, other matters that don't necessarily need to be discussed and debated. When it comes to more significant matters, that's when you really do want to get into the boardroom, and that's regardless of whether the consents are being delivered in traditional paper form or through a board portal. One is I will say, in terms of meetings, when you do have significant matters, it is better to get the board into the boardroom, and in this context, having them all have all the materials through the portal is a good idea as well.
I would imagine that the kind of time sensitivity of an issue would play into it. If something can wait for the next board meeting, you might as well wait, right? But if it has to get done fast, then you can start to evaluate whether it's appropriate for written consent, right?
I think that's exactly right. I mean, if something has to happen on a time sensitive, urgent basis, and it's something that the board has been considering for a while, or if it's absolutely urgent and someone has is off in the Sahara and has access to the portal but doesn't necessarily have the ability to get on a phone call, well then I would think that's kind of you view these things on a case by case basis.
Okay, good. Well, listen, let's start to wrap this up. I want to ask a final polling question of the audience before we conclude. So let's look at question number 4. And after this discussion, really, and this is perhaps a question more for the 73% of our audience that are not yet using Board Portal, but also really for the other 27% that are, and maybe what are some of the barriers that slowed your entry into it. But A, what is it legal issues that are stopping you? Is it security? C, is it simply changing people's habits? Or really, is it all of the above? We'll start to look at the answers coming in. And Jeff, in your experience, in talking to clients, what are some of the things that those using voting have had to overcome, and what's stopping others?
Well, I think that typically it is just a matter of changing a traditional process. When people started using voting within diligent board books, initially it really was for one of the things that John Mark was talking about, which was signing off on minutes. A lot of companies were either faxing pages that had to be signed or FedExing things, and the portal made it obviously a lot easier to compile people's signatures. But I think for a lot of companies, they didn't necessarily see it going farther than that, or there's just ingrained practices that it's not that they're not interested in changing, it's just that they've done things a certain way for a long time, and that's how they do them. So I mean, for us with the board portal, what we find is that where people very quickly will adopt the concept of being able to have real-time, updated information to the most recent version of their board and committee materials, they don't necessarily think about all of the other many features for the board portal. And, perhaps, one of the things that will drive us is just us continuing to remind people that these are features that the board portal has. I think that there are things that do have to be addressed, such as the legal issues, but really for the most part, it's just a matter of making people aware that it is something that they can do and helping them move towards that practice. And
certainly that's really reflected in the results that we just gathered. 77%, nearly 80% of the audience said that simply changing people's habits is the main barrier, although another 10% said it was all of the above, including legal issues and security. So pretty interesting results. Now, we're going to conclude this webinar. We did get one fairly technical question about timestamps and voting that Diligent will respond to directly. But for now, I want to thank very much John Mark Zaberkowitz from Richards, Layton & Finger, also Jeffrey Powell, Executive Vice President of Sales North America at Diligent Board Member Services. This webinar on board portals and voting presented by Corporate Secretary, along with our partner and sponsor for the event, Diligent Board Books. We will make the replay available on corporatesecretary.com, and you can find a lot of good information about board portals on our site, but of course from Diligent as well. Just go to boardbooks.com. Thank you very much to our audience. Thank you for your questions, but especially to you, Jeffrey and John Mark. Goodbye.